The atmosphere in Courtroom 5 at the San Francisco Federal Building was unmistakably tense. What should have been a routine hearing on Representative Jasmine Crockett's request for a temporary restraining order had unexpectedly turned into one of the most watched legal moments of the year. Judge Edward Chen, recognized for his sharp mind and occasionally curt demeanor, had just finished reviewing Crockett's emergency motion. His face showed clear disapproval as he looked over his glasses at the Congresswoman, who had chosen to argue the matter herself. "Representative Crockett," Judge Chen began, his voice echoing through the crowded courtroom. "I've read your motion, and I am genuinely puzzled how someone with legal training could file something this fundamentally flawed." Holding the document lightly between two fingers, he continued, "It lacks basic legal grounding. The precedents you cited are either irrelevant or incorrectly applied." A murmur ran through the rows of reporters and court observers. Several lawyers exchanged knowing glances, anticipating a judicial rebuke that might soon be repeated across legal circles. Then came the unexpected turn. Rather than appearing shaken by the judge's critique, Crockett walked steadily to the podium. With quiet confidence, she opened a leather-bound legal text that no one had noticed before. Within moments, Judge Chen's dismissive expression shifted to surprise as Crockett referenced an obscure, but directly applicable legal precedent. Even the court clerk briefly stopped typing, surprised by the shift. The veteran courtroom bailiff, familiar with thousands of hearings, paused as the balance in the courtroom seemed to change instantly. Don't forget to like this video and subscribe for more important courtroom and legal breakdowns. Hit the notification bell to stay updated on major cases shaping America's judicial landscape. Judge Edward Chen, 71, was widely known as one of the most intellectual judges on the federal bench. Appointed by President Obama in 2011 to the U.S. District Court for the Northern District of California, he had previously served a decade as a magistrate judge. Before joining the judiciary, he spent 20 years at the ACLU, working on landmark civil rights cases that influenced California's legal landscape. Born to Chinese immigrant parents who operated a small Oakland restaurant, Chen graduated from UC Berkeley and later Harvard Law School with honors. His legal skill was never questioned, but lawyers often noted his impatience with unprepared arguments. "A courtroom isn't a training ground," he once said. "If you take the court's time, you must know your case completely." Judge Chen's stern style was rooted in a deep respect for legal accuracy. He authored major decisions in the area of digital privacy and had been mentioned as a potential appellate court candidate. According to legal analysts, his sometimes sharp tone came not from pride but from frustration when arguments fell below professional standards. Facing him was Representative Jasmine Crockett, 43, serving Texas's 30th congressional district. Now in her second term, she still actively maintained her law license, taking on select civil rights cases. Before politics, she had been a highly effective civil rights attorney in Texas. A graduate of Rhodes College and the University of Houston Law Center, she won multiple significant cases, including bail reform in Dallas County and a voting rights challenge protecting minority voters. Known for her exceptional memory and strategic legal style, Crockett personally read and annotated extensive case law before major arguments rather than relying solely on research support. "Law isn't only about rules," she once said. "It's about understanding how those rules have evolved." Crockett's emergency motion sought to stop a new Department of Justice directive that would immediately affect thousands of residents in her district. The directive, issued only days earlier, would sharply limit access to certain federal benefits in specific congressional districts, including hers. If the court denied the motion, many vulnerable families would lose support within 72 hours. DOJ attorneys argued the policy was a necessary security measure. Crockett argued it was unconstitutional and improperly enacted. Debate intensified because she chose to argue alone, without her congressional legal team. Critics called it political theater. Supporters viewed it as personal commitment to her constituents. Court staff had prepared extensively, reviewing both legal issues and Crockett's record. Some believed she had exceeded her role by arguing herself. "Representative Crockett," Judge Chen stated again, his tone firm, "your motion misinterprets the Administrative Procedure Act. Cases like Lincoln v. Vigil and Norton v. Southern Utah Wilderness Alliance actually weaken your position. Additionally, your final agency action argument contradicts the Supreme Court's reasoning in Bennett v. Speer. Did you review that case? Government attorneys glanced confidently at each other. Observers shifted uneasily. Professor Miranda Jimenez, a constitutional law expert present in the courtroom, whispered, "He's speaking to her like she's a first-year law student, not an experienced attorney." Crockett listened calmly and moved to the podium. "Your Honor, thank you for outlining the court's concerns," she said evenly. "If I may respond point by point." Judge Chen nodded, expecting a political defense rather than a legal one. "Regarding Bennett v. Speer," Crockett said, "the distinction lies not in the finality language there, but in Justice Scalia's reasoning in Whitman v. American Trucking Associations." The judge's demeanor shifted as she continued. In Whitman, the court held that agency action may be final, even when implementation details remain unresolved, if the action creates binding norms affecting regulated parties immediately. She then referenced a D.C. Circuit case applying similar reasoning, followed by a Ninth Circuit case she had cited in her filing. "Page 17, Your Honor," she pointed out calmly. Judge Chen checked his brief, visibly adjusting his posture. Crockett continued, "And regarding Lincoln v. Vigil, the opinion distinguished between general funding decisions and actions removing previously granted benefits. Page 23 of our motion, Exhibit C, documents the DOJ's internal acknowledgement that this directive changes established practice and removes existing eligibility." Observers leaned forward. "She's dismantling every point," Professor Jimenez whispered. Judge Chen, now more attentive, shifted tone. "Let's address your equal protection argument," he said. "You haven't justified strict scrutiny." "With respect, Your Honor," Crockett replied, "we have, although through a less traditional route." She referenced Department of Commerce v. New York, the census case, explaining that even seemingly neutral government actions can undergo heightened review if evidence suggests pretext and disproportionate effects. She pointed to FOIA-obtained internal agency communications attached as exhibits. Government lawyers appeared unsettled. "Exhibits D through G submitted 5 days ago," she reminded the court. The DOJ asked for time to review. Judge Chen agreed to a 15-minute recess. Conversation filled the courtroom. Even the judge's clerk returned with additional materials. When the court resumed, Judge Chen leaned forward. "Representative Crockett," he said, "please expand on how you link the Department of Commerce ruling to Arlington Heights in analyzing governmental motive." The targeted constitutional question made clear that the judge now regarded Crockett as a serious legal opponent. The courtroom grew quiet, assuming the judge had finally regained control of the session, but Crockett's reply would shift the exchange dramatically and shape the direction of the hearing. "Thank you for that question, Your Honor," Crockett began, showing no sign of being unsettled by the judge's technical inquiry. "The connection between the Commerce ruling and the Arlington Heights test is exactly what I intend to explain." She moved away from her papers, signaling full confidence in the material. As this court is aware, Arlington Heights created a multi-factor framework for identifying discriminatory intent. That includes historical context, the sequence of events behind the challenge decision, irregularities in the usual procedure, and legislative or administrative history. Judge Chen nodded, watching closely. "What makes the Commerce decision important," Crockett continued, "is that it essentially lowered the proof required to trigger greater scrutiny when there is evidence of pretext." She referenced Chief Justice Roberts. "We are presented with an explanation for agency action that is inconsistent with what the record shows about the agency's priorities and process." She paused. "That standard, consistency with the record, provides a clearer method than the more traditional Arlington Heights elements, especially in administrative cases where discriminatory intent may be concealed." The judge leaned in, clearly interested. "But Arlington Heights is still controlling law," he noted. "Absolutely, Your Honor," Crockett replied. "I am not arguing that Commerce replaces Arlington Heights. Instead, it provides a complementary analytical approach." She reached into her briefcase and pulled out a journal. In Regents of the University of California versus DHS, the DACA case, Chief Justice Roberts again addressed pretext. though the main ruling concerned the Administrative Procedure Act. Footnote 7 on page 1909 ties that analysis directly to equal protection. The judge raised his eyebrows. Few lawyers cite specific footnotes from memory. She quoted, "While these considerations are not relevant to the APA review, they are certainly relevant in an equal protection challenge. These same types of evidence," she continued, "appear in Exhibits D through G. Internal communications contradicting the agency's stated justification." Judge Chen's demeanor shifted. Now the discussion was substantive. "Even assuming your reading of Commerce and Regents is correct," he said, "you still must show that the disparate impact here reaches the level requiring heightened scrutiny." Crockett nodded. "That is where our evidence is pivotal, Your Honor. If you review Exhibit E, page 4, it shows an internal memo acknowledging the directive would impact majority-minority districts at a rate roughly 8.7 times greater than majority-white districts." A quiet reaction moved through the courtroom. "And on page 6, she continued, "the agency's legal team warned that this disparity created serious equal protection risks that could expose the directive to constitutional challenge." The judge turned to government counsel. "Mr. Reynolds, can you respond to these documents?" The DOJ attorney stood. "Your Honor, we see these as preliminary staff opinions, not final agency positions." "But they were never formally rejected, were they?" Crockett interjected. "And the agency never performed the impact review its legal office recommended." The DOJ lawyer looked uneasy. "The record shows the factors the agency considered relevant," he said. "And that is the problem," Crockett replied. "Commerce makes clear the court may look beyond the administrative record when there is evidence of pretext. Justice Roberts wrote, 'We cannot ignore the disconnect between the decision made and the reasoning offered.'" The judge nodded, then returned to a previous issue. "Let's discuss your use of Lincoln versus Vigil. You argued Justice Souter distinguished general funding decisions from actions that withdraw established benefits. Explain how that applies here." This was a turning point. The judge was now openly reconsidering his earlier critique. "Certainly," Crockett said. "On page 170, Justice Souter explains that while agencies have broad discretion in allocating funds, that authority does not extend to eliminating previously granted rights." She flipped to another tab. "And in Weyerhaeuser v. U.S. Fish and Wildlife Service, the court confirmed that agency discretion is limited when constitutional or statutory boundaries are at stake." She paused. "But the most relevant case, which has not yet been mentioned, was issued 3 weeks ago by the D.C. Circuit. In Center for Biological Diversity versus Office of Management and Budget, the court held that when an agency directive effectively changes statutory text by creating new categorical exclusions, that action is reviewable, even if framed as resource allocation. The courtroom went silent. Even Judge Chen appeared unfamiliar with the ruling. "I have copies for the court and opposing counsel," she said. "While persuasive, not binding, I believe Judge Srinivasan's reasoning applies directly here." Judge Chen skimmed the document, interest clear on his face. "Representative Crockett, this is strong research," he said. "How did you find this case so quickly?" "I clerked for Judge Srinivasan before entering private practice," Crockett replied. "We have stayed in contact regarding administrative law developments. He suggested this ruling could have broader implications." The room grew still. Judge Srinivasan is widely respected and often considered a potential Supreme Court nominee. His former clerks are regarded as top-tier legal minds. Everyone present absorbed the significance of that revelation. Law students in attendance reacted visibly, some nudging classmates and whispering with interest as they realized they were witnessing a moment they would likely discuss long after graduation. A law professor seated in the back row immediately began typing notes into her tablet, already imagining how this moment could be used in an upcoming administrative law lecture to demonstrate courtroom strategy and composure. What made the exchange particularly notable was that Crockett mentioned her connection only after her thorough arguments had already established her legal command. She did not rely on her background up front. Instead, she allowed the strength of her reasoning to lead, showing a disciplined strategy rooted in merit over status. Judge Chen set down the opinion and removed his reading glasses, a gesture that longtime observers knew signaled an important shift in the courtroom. "Mr. Reynolds," he began, turning toward the government's attorney, "the court would benefit from the government's response to this new precedent. However, it appears you have not reviewed it yet." The DOJ attorney rose, clearly uneasy and caught off guard. "That is correct, Your Honor. We respectfully request time to review the case and prepare an appropriate response." Judge Chen nodded. "That request is reasonable." He turned back to Crockett. "Representative, your legal arguments have raised substantial issues that deserve thorough review. While I initially had reservations about the basis of your motion, you have provided precedent, including recent authority, that may ultimately control in this matter." This statement was highly unusual for a federal judge, a public acknowledgement that his initial assessment had underestimated the argument. "In light of the new information and arguments presented," Chen continued, "the court will issue a temporary restraining order halting implementation of the directive for 14 days, allowing the government time to respond in full." A ripple of surprise moved through the courtroom. What looked like a routine denial only moments earlier had shifted into a significant victory for Crockett. "Representative Crockett," the judge added, "the court commends your thorough preparation and presentation. Today is a reminder that we must avoid assumptions about the capabilities of those who appear before us, regardless of their current roles." It was, in effect, a respectful apology, especially striking coming from a judge known for precision and rigor. Spectators exchanged astonished looks. Crockett remained composed and professional rather than celebratory. "Thank you, Your Honor. My goal was simply to ensure the court had the benefit of all relevant precedent when deciding an issue of great importance to my constituents." As the hearing concluded, quiet conversations filled the room. Reporters immediately hurried out to file breaking stories. Legal observers who expected a routine procedural moment instead saw a real-time example of advocacy reshaping judicial thinking. DOJ attorneys gathered their materials, their posture reflecting surprise and frustration. Yet one attorney stepped forward to shake Crockett's hand, an acknowledgement of the professional skill she displayed. Professor Jimenez leaned toward her colleague, eyes wide. 20 years in federal court and I've never seen anything like that," she whispered. "She didn't just win, she changed the judge's perspective." Her colleague nodded. "And not once did she raise her voice or appear shaken. That level of calm is something every law student dreams of achieving." As Crockett collected her documents, a group of law students approached her with admiration. One asked how she prepared for such a demanding hearing. "The law is always there if you know where to look," Crockett replied softly. "Today showed that in a courtroom, your title isn't what matters. Preparation and respect for precedent always come first." The importance of what happened extended beyond the immediate outcome. A respected federal judge publicly revised his view based on the quality of legal argument, not on the attorney's political role. It demonstrated that sound legal reasoning can overcome assumptions, even in formal judicial environments. News spread quickly. Within hours, legal media outlets covered the hearing, calling it one of the most notable courtroom shifts in recent memory. Law 360's headline read, "Judge Chen reverses course after Rep. Crockett's administrative law masterclass." The case's significance lay not only in the result, but also in what it represented for how attorney legislators are perceived. Judges often assume elected officials lose some legal sharpness. Crockett disproved that assumption decisively. "This challenges long-held beliefs," said legal scholar Erwin Chemerinsky on NPR. "Judge Chen is extremely rigorous. For him to publicly credit her persuasion with that is extraordinary." Crockett's standing rose immediately. The ABA asked her to keynote its national conference. Harvard, Stanford, and other top law schools invited her to speak about courtroom performance under pressure. "What we witnessed wasn't simply good legal work," said the dean of Berkeley Law. "It was a textbook example of preparation, poise, and strategic thinking in a difficult environment." Public interest matched the legal reaction. The hearing video, federal courts in that district allow cameras, racked up more than 3 million views within 48 hours. Legal education platforms requested rights to use excerpts for training. Judge Chen also gained respect. Commentators praised his willingness to reconsider, a rare act in a profession where hierarchy and certainty often dominate. He demonstrated judicial integrity, wrote a Washington Post analyst. When the law pointed another direction, he followed it. That is how trust in institutions is restored. 3 days later, the U.S. Court's Administrative Office announced new judicial impartiality training. While not naming the event, the timing made its influence clear. Within DOJ, internal reviews showed junior lawyers had flagged the relevant precedent, but senior attorneys dismissed it. Their oversight led to new preparation reviews and revised internal guidance. "We underestimated congressional attorneys," said one senior DOJ official privately. "That will now change." Media outlets also began highlighting lawmakers' legal credentials more seriously. The case shifted newsroom habits, prompting more balanced coverage of elected officials with strong legal backgrounds. Minority legal groups celebrated the moment. The National Bar Association reported increased interest from young prospective law students referencing Crockett. "Seeing a black woman Congresswoman command respect through pure legal skill, that matters deeply," the association president noted. The impact reached judges as well. In following months, judges nationwide appeared more respectful toward legislators arguing cases personally. This moment came when confidence in legislative and judicial institutions had been low. The hearing offered a rare reminder that reasoned legal debate could still shape outcomes and rebuild trust. Bar associations released CLE programs on the Crockett approach, emphasizing preparation, emotional control, and strategic argumentation. These programs spread quickly among attorneys and even judges. Law schools adopted the transcript widely, using it to teach that effective advocacy can rely on careful citation and calm delivery, rather than dramatic tactics. Half a year later, at a Ninth Circuit judicial conference, Judge Chen reflected on the experience. "That hearing reminded us never to judge legal skill based on one's title," he said. "Excellence exists in many forms." The temporary order eventually became a permanent injunction when DOJ chose not to challenge Crockett's arguments further. The precedent she introduced gained wider adoption, strengthening limits on policy carried out through informal directives. Professor Elena Rodriguez at Columbia created a seminar around the hearing titled "Turning Points in Oral Advocacy." It shows students that precision and calm can overcome skepticism, she explained. Nearly a year later, Chen and Crockett appeared together at a major administrative law symposium. Their joint session drew an overflowing audience. When asked about their courtroom moment, Chen said, "It was never about winning or losing. It was about respecting the law enough to change course when required." Crockett added, "Preparedness and respect for the process matter more than job titles." Their conversation reflected mutual admiration and highlighted a shared commitment to legal principles over ego. The encounter turned into a landmark teaching example, redefining expectations for elected attorneys and reminding judges and the public that expertise exists across professions. If you found this expanded breakdown insightful, remember to like this video and subscribe for deep analysis of key legal moments shaping the American justice system. Enable notifications so you never miss future coverage that moves past headlines and digs into the true mechanics of impactful legal advocacy and precedent building. Real legal understanding develops by studying strategy, precision, and the moments where preparation turns unlikely hearings into transformative outcomes.